Welcome back, everyone. It's the lawyer you know, and today I want to provide a quick update, answer the most asked question about the Curtis Reeves case, which is going to trial right now. Former law enforcement officer who shot someone in a movie theater and is now claiming self-defense. Everybody in the comments of the first video wanted to know why this case took 8 years to get to trial. So we will answer that question, provide a brief update on how jury selection is going. This is midday Tuesday, and then again ask you for more of your questions in the comments because that is what breeds the best conversation. So if you haven't subscribed to our channel already, please take a second to do that so you can get in the comments, talk to us about these cases, and if you enjoy the videos, as always, hit the like button so we can continue to make content that you are most interested in. So 8 years. 8 years for a criminal case to get to trial, and there are a lot of reasons for it. I want to start by saying that it won't take 8 years if either side's lawyers is pushing it to go as fast as they can. So both sides of lawyers had to be partially agreeable in allowing this case to drag on for so long. And the packed courts and COVID, the pandemic, all of that, of course, had to do with it. But when you look on the defense side, why they would want to delay this case and continue, their client was out on bond and house arrest throughout most of this pretrial phase. So he was not in prison, and he's a 75-plus-year-old man dealing with a lot of ailments, and now I believe he has cancer. So being at home for him and not being on trial for murder is probably a pretty good result at this point for as long as they could. And the prosecutor's office, a lot was going on. And the prosecutor's office is always busy, always overworked. So sometimes cases can fall through the cracks if the defense attorneys are not pushing them to go to trial as quickly as they possibly can. But in this case, not a ton of blame goes on the lawyers. So I will say the lawyers could have demanded speedy trial. They could have tried to push it faster. It may have affected it a little bit. But there are a lot of very specific, nuanced reasons why this case specifically took so long to get to trial. And the first reason is the stand your ground component. The stand your ground component is a separate hearing, and it's basically like a full-blown trial. I think it took about a week in this case. And the defense lost. And once they lost that stand your ground hearing, they appealed it. And that appeal is an interlocutory appeal, which means the case is stayed and the case stops until the appeal is heard and ruled on. So the defendant appealed that case up, and they lost that appeal. So once they lost that appeal, they continued litigating this case. But another issue with stand your ground, specifically in this case, is the law changed in Florida. The old law was that the defendant had the burden to prove that it was self-defense in a stand your ground hearing. And now the Florida Supreme Court has flipped it, and the new law is that the state has the burden to prove that the defendant did not act in self-defense, and they have the burden of proof in a stand your ground hearing now. So that burden of proof has shifted from the defense to the plaintiff, specifically in a stand your ground hearing. And don't get confused, this is not a criminal trial. The state still has the full burden of proof in a criminal trial. The defense never has a burden of proof in a criminal trial unless they have certain affirmative defenses, but this is specifically in the stand your ground hearing in Florida. The old law, the defendant actually had that burden of proof. So once that law changes, this case, they had to wait for the Florida Supreme Court to rule as to whether or not it was retroactively applied. And if it was going to be applied retroactively, then it would have affected this case, and potentially they could have had another stand your ground hearing once the burden shifted to the prosecution, because in their stand your ground hearing, the defense had the burden. So were they going to get another hearing? And the Florida Supreme Court said no, it does not apply retroactively. It only applies to cases that happen after the law changed. So that burden only shifts if your stand your ground hearing or claim happens after the law change. So this case happened before the law change. Therefore, the old law would apply. The defense will have the burden of proof in the stand your ground hearing, which is exactly what did happen. So they did not have to wait and have another hearing, or there would have been even more delays and potentially another appeal there. But they did have to wait for the judges to actually make that decision. Because until they made that decision, they don't know if they got a fair shake at the stand your ground hearing. And an additional thing that happened in this case was a second interlocutory appeal that actually happened earlier in the case and doesn't have anything to do with stand your ground. And an appeal the defense actually won. and that was appealing the no bond order or no bail order. So it was ordered that he would not have bail or bond in this case. The defense appealed that, stayed the case until that appeal was heard. They won. He ends up getting out on bond and on house arrest. So they actually won that appeal, but that was another delay because the case was stayed again. And so with those delays, with the pandemic, COVID, the packed courts, and neither set of lawyers really seeming to push this case to go as quickly as possible, which you can understand from the defense side, when they have a client that maybe isn't so unhappy about being at home in his late 70s dealing with all of his medical issues, that's how it took 8 years for this case to go to trial. So we're on day 2 now of the technical trial. They're still picking the jury. They did a lot of motions in limine yesterday saying what's going to come in and what's not going to come in at trial. And the jury selection in this case is going rather slowly. They brought in 50-ish people. About half the crowd, when they were asked if they heard about the case, raised their hand that they had heard about the case. And a number of people were struck because they already felt like they had made a determination about guilt or innocence in this case. And I'll just let the cat out of the bag and tell you, most of them felt like the defendant was guilty and they didn't need to hear any evidence. They already felt like they had made up their mind. So those jurors were obviously struck and they will continue with jury selection. And in this case, state court, criminal court, the lawyers will have a lot of leeway in asking these jurors questions, talking to them about this case. It's a high profile case, a lot of media coverage. There's going to be a lot of questions dealing with that. And it's interesting, in this case, in criminal cases, most of the time it's different than civil cases. And they talked about how the lawyers were given the jury questionnaires that the juries fill out with their demographics and their jobs and connection to law enforcement, connection to other cases, whether or not they've been a juror before. They go through all those questionnaires in the courtroom right before jury selection starts. In some cases, especially civil cases, at least here, the lawyers can get that stuff ahead of time. There are these companies centered around doing social media research and figuring out as much as they can about these jurors. Well, that doesn't happen in all these criminal cases. In some of them, like this case, you get the information just a few minutes before you start asking questions to get to know this jury and determine whether or not they can be fair and impartial for the case that they are about to sit on. So, jury selection is probably going to take a couple days. We'll keep following along. We'll keep providing updates. But really, what I want to know in the comments, do you think it was appropriate for it to take 8 years to get here based on everything that you heard? And do you have any other questions about this case? Because that made it really fun, easy content for a video to answer the question that most of you had. So thanks for the questions. Keep them coming, and we'll have more next time. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.